Hi, good afternoon, and welcome to today's edition of the Law and You. I'm your host, Attorney at Law Shellon Washington, bringing you every week from my firm, Washington Law Firm, sponsored by the Washington Law Firm, located at 455 Utica Avenue, Brooklyn, New York. Thank you for joining us today, guys. Today we're going to be discussing trust in estates. We're going to be discussing how to protect your estate, how to make sure that in the event of anything, your estate is well protected. And joining me today is Clairmont Chung. I'm not going to be alone today. Today I have a guest joining me. He is here. So let's get Clairmont Chung here from backstage, and let's get into the program today. Hi, good afternoon, Clairmont. How are you?
I'm fine, thank you. Thanks for having me. I hope we have a productive program.
As always, for those of you watching again, we're going to be discussing with asset protection, trust and estates, and how you're going to find out today some of the ways you can make sure that in the event something happens to you, your asset is going to be protected, and it's not going to be wasted on legal fees and different types of fees, so that your beneficiaries will have the most or optimal benefit from your estate. So Clairmont, you were here before and we discussed some of the ways to protect assets. Could you go ahead and discuss again some of the ways, and then we could go into some specifics about it?
Right. Well, generally, when we talk about protecting assets, we're talking about protecting assets after death. Of course, you have to do it while you're alive to protect, so that it won't get into the wrong hands or unintended hands. Now, of course, planning is not just about after death. You plan how you'll manage your money in your life as well. And of course, if you lose capacity and you're not able to make decisions for yourself, could you really depend on the people around you to make decisions beneficial to you that will keep you in the kind of condition that you would want for yourself? So these are all kinds of things that you want to be thinking about when you're thinking about trust estates. And the addendum to that is estate planning, which I don't think we are going to get into that today, but there are countries with the same border. You can't really, they operate together. But for our purposes, and answering, Shellon, your question, is that we're trying to protect our assets while we're still here and even after we're gone, and make sure that the right people benefit from our hard work and labor.
Yeah, absolutely. And for those of you who've been paying attention to my shows, you will know that I am always preaching about protecting the assets for the generation behind you. Of course, while you're here, you'll be able to manage it properly, I guess. But in any event, you need to put measures in place to protect those assets and ensure that the people following behind you will enjoy those assets to the max. Clairmont, I think I want to discuss a scenario. One of the ways to protect assets, which we've talked about before in this show, is using a trust. And there are different types of trust. But the one that I've discussed mostly on this show is the revocable living trust. And I'm going to let you talk a little bit about the revocable living trust, and then we're going to discuss a specific scenario of what people want to avoid happening in the event something happens to them. So could you expound a little bit about the revocable living trust?
Right. Well, so the name tells you a little bit about it, in that it's revocable, meaning that you can change it. You don't have to live with a bad decision if you make a bad decision, as sometimes humans do. So it's revocable or revocable because it's just that. However, that doesn't lessen its power. It's still a very powerful document, because it's like it creates a person. That's no easy job. So the trust is like a real person. It has an identity. It has a social security number. Um, it can open bank accounts. It can run businesses. It can own property. This is a real tool in your quiver that you should be able to use, because you create something other than yourself. And you don't have to, it's not a child, you got to nurse it or send it to school and pay university. You create a whole new person, an adult that thinks like you. In fact, it is you, except it's not. So that kind of powerful tool we should be using more of. And the way we use it is a number of ways, right? So one of the most popular uses is to avoid the cost of probate. Probate meaning if you die without a will or with a will, you still have to go to court. If your assets are over a certain minimum, you still have to go to court to get an award from a judge, really permission from a judge to take control of the assets. Someone else has to do that now that you're gone. And you really don't control who that person is going to be if there is no will. In the case of where there's no will, really anybody technically can apply for letters. And once they could show they have a reasonable knowledge and so on, they can take control of how to distribute your assets. Now, the reason that almost anybody could take control is that once there's no will, then it has to be distributed according to the law, which is that person, whoever they may be, has to follow that law. But that doesn't mean they can't siphon off money for themselves to do things that they want to do. And so, you don't want to leave that in that kind of situation. So the trust then takes the legal work out of the court's hands, out of a third party's hands, and put it in the hands of somebody you trust and and you believe will do what you require. In fact, what you require is written into the trust. So you tell them what to do. And if they don't do that, then someone else who can come and say, you're not following the rules, you're not the trust, the deceased, which in this case, it'll be you, that's not what you wanted. And so someone could challenge and correct it and so on. And the cost of the trust, it might be a little more money up front, but it's cheaper in the long run because you don't have to pay court costs. Attorneys come at a very high rate. You can ask Ms. Washington, she'll tell you. Attorneys are expensive. So a trust might be the cheaper way to go. Anything else that I miss?
Right. I mean, even if you miss it, I will catch it. And I want to make sure the audience understand. I don't want you guys to get scared when you hear trust and you hear deceased, the word deceased. No, don't get scared, because first of all, a trust is one of the most powerful and most effective way to protect your asset and pass it around for generation to generation to generation. And I always tell people a trust exists in perpetuity. Like most people in America know about the Hershey's Trust. Most people have gone to Hershey's Park before. And if you've gone there, they would have explained to you how Hershey's operate under a trust. And it passes down, the trustee changes. That's it. So with the trust, you have the settler, which we would have heard claimant refer to as the person who's gone. But that's the settler. And a trust could exist while you're alive also. It exists while you're alive and it continues after you're gone. So you're the settler, and then you have the trustees. These are the people who you put the property or entrust the property to them. And the trustee can hold the property, or you can have the property held by the trust itself. You heard Claimant mention the fact that the trust exists as an independent entity on its own. So once that trust is created, you can get the tax ID number, you can get a bank account, you could do all these things for your trust, like he said, and it exists as a independent person or entity, I would say, right? So in that case, once you're alive, you can dictate, you can put certain things into the trust, stating what your wishes are. If you want the property sold while you're alive, if you don't want it sold while you're alive, you can put restrictions. You can say that the trust must continue, like I was saying, in perpetuity. So it will continue indefinitely, and it ultimately will change trustees. So you can make yourself a trustee also. You can be a trustee under your own trust, and then you have successor trustees. And whoever is going to be the trustee is going to name the new or the successor trustee, and the trust will continue like that. That's for the revocable. And like you hear Clement said, if you believe you made a mistake, you can change that at any time because it's a revocable living trust. Of course, you have the irrevocable ones, which cannot be revoked except in limited circumstances by court order. So you got to be very sure if you want to do a trust that is irrevocable, you can't change it no matter what. Be careful because it could only be revoked in limited circumstances. But the revocable one, you can change your mind at any time and you say, you know what, I'm going to create an instrument revoking this trust because I don't want it to continue. But as Clairmont said, it saves you money in the long run. Now, Clairmont, could you discuss a scenario that, I have a lot that I've encountered where a trust would have been adequate to protect the family assets, but it wasn't done. So do you want to discuss a scenario where you think this would be very helpful to our audience to know so that they will avoid that type of pitfall?
Well, I can think of a number of examples, but one is that I had to evaluate. Recently, someone died, and this is a good ending story. They're not always good ending stories because people don't take care of the business while they're alive. But this particular woman had come from the Caribbean, had worked hard, put aside her money, bought a house in New York, had 3 children, and she went a long time ago before I even knew her. I did not do the trust. She went to an attorney and had a trust done. And so when at the end of her life, she lived 5 years before she actually passed. She suffered from dementia, and she didn't know who, she couldn't recognize anybody. She couldn't recognize even her own children. So had she waited, she would not have been able to do all of that. And then someone else would have to intervene and do it on her behalf. So she was smart enough. And this is a person with, no real formal education. This is just a hardworking, blue collar person. So she went and she did her trust, and then when she passed, one of her children brought it to me to exercise the power as she, the mother, wanted it. So the thing about it, what's important about it is that we're not created equal, and the mother who passed was aware that her children were not created equal. She knew who was capable, and she knew which one she felt would not be capable. So she put the one who she thought would be capable as the trustee and to execute the trust. That was the one who came to me. And based on my evaluation, she was right. She chose the right person. This is what you have to do. This is why it's so important. All the children that I now had to meet in some kind of way, she chose correctly, that this was the right child to do this work. And so my work was easy. All I had to do was to follow through. I didn't even have to ask the court or anything. I just, filled out whatever I had to fill out for the bank. The house, everyone had their own properties, so they didn't need the house and didn't want the house anymore. We sold the house. The trust sold the house to somebody. They took that money, divided it among the children, just like the trust told them. And within weeks, this was all done. Now, compare that to somebody who wrote a will or didn't write a will, either one. We would have been sometimes 2, 3. I've had one that has lasted. I got involved in 2017 and it wasn't resolved until 2024. 7 years because of the, infighting and all of that and all the different heirs and so on and so on. It took 7 years to resolve. Meanwhile, the one good thing about that, and this is only in New York, there was property involved, and the value of that property kept going up. So it didn't hurt as much. But still, there are other places where property doesn't increase in the same rate, and you'll be waiting for the same money for 7 years, and that's not a good thing. So this is a feel-good, end-well story, but you should take note that some of them are not like that.
Right. And, that is so true because one of the situations I would like to share is a case with it was a well-educated woman. She came to this country. Fortunately, she had no children. She had no heirs except for her siblings. And she came and she worked hard. And I'm not too sure about what the circumstances, but she was sued. And then after she passed, the lawsuit continued against her. But what I would like to point out to people so that they will know that the trust serves a protection from lawsuits. It protects your assets from claims against it. So had she put her assets into a trust, when she passed, even if the lawsuit continued, she would have owned nothing. So there would be nothing to enforce anything against. So it's really important that your assets be protected from lawsuits, from claims, from debtors, from all these things. Once you put that your assets into that trust, you need to take all the steps, particularly transferring the house into the trust, transferring your bank account, all of your, whatever you own, your savings, your investment accounts. It's worth it transferring everything into the trust. So once anything happens, it's just the trustee has to take the necessary steps to do whatever to manage the assets if you want the trust to continue indefinitely, versus if you want the trust to come to an end at your death, because it can come to an end once the settler dies, or like I said, perpetuity. The rules against perpetuity doesn't really operate like that when it comes to a trust. So you can have the trust continue indefinitely, and you want to avoid the pitfall like the estate I'm telling you about, where the estate is become a part of a lawsuit. You don't want your estate to be sued. You don't want your estate to be dragged through court, and then the beneficiaries has to pay legal fees, or your trustee has to pay legal fees from your assets so that they can defend your estate. These are things you can simply avoid by putting the trust in place to ensure that no matter what, your trustee is not going to have the burden of dealing with any type of lawsuit or even with the court, because you skip the whole process of going through a court to do probate, as we do under a will. A will, we have to do probate. We have to probate the estate. So there's filing fees. If there's real estate, there's broker fees. We have to sell the property. And for those people from Guyana, just know that we don't, in America, in New York, we don't sell property the way we sell property in Guyana. In America, we require most of the times, you could avoid it if you have a direct buyer, but most of the times you have to hire a real estate company to list the property to increase the likelihood of getting it sold quickly. And if you don't hire a broker, then you're stuck with the fact that it's going to take its time to get sold on the market. And you could avoid the broker fee, avoid everything else by ensuring that the property is in a trust. And even self, if you want the property to stay in your family for decades to come, you could ensure that, the trustee there's is an option under that trust that one of the beneficiaries could potentially purchase that property and keep the property in the family for a long time to come. Now, Clairmont, back to you now. We have already discussed some of the pitfalls that people could, possibly avoid. I've talked about litigation. You've talked about avoiding the court system. Is there anything else that you would like to touch on as it regards to things that could be avoided by simply getting a trust?
Right. So even before getting to the trust, there are some things you could do to avoid even a trust. I mean, you want to do the trust for the things that you can't that you can't otherwise gift without penalty. And so even before you get to the trust, there are things you could designate beneficiaries for some of your assets. I mean, even for a property, you would probably need some consultation, given your personal situation, as to whether a property might be useful to gift while alive, or add someone else's name, depending on their ages and so on. There might be issues, but there are things that you can transfer before, even without a trust or a will. Of course, insurances, you have a beneficiary, bank accounts, you could, 401ks, by law, you have to assign someone. If you're married, it has to be your spouse. If not, then you name someone, a child or whomever you wish. So yes. And then, of course, if none of that applies to you, but there are still assets, then a trust would be the thing for you. Of course, if you have no assets, then this is a dead issue for you. But if you do have, especially real estate, or even a business, a income producing business, the trust would be a thing to manage and to be a way of avoiding certain kinds of taxation. When you transfer property to a trust, it's different from if you're transferring that property to an individual. The trust uses the basis that when you bought it, because now, even though it's a different entity, it's you who's creating the trust. So it uses the bottom purchase price of the house as from when you bought it. And if you were to sell that property or gift it to a family member, they're going to use the new price, or maybe it's the other way around, I think.
Market value.
Yeah.
Yes.
So your taxes are based on a much larger income than if it was a trust. So the trust offers the least tax liability if you're going to transfer to a person or the trust. The trust offers the better, and I think that's a huge advantage, especially if you're in New York and you're looking at houses in the range of $1 million and above. You're looking at substantial taxes. So save yourself the agony of paying out your hard-earned money to the state by creating a trust rather than gifting it to a relative or a friend.
Right, guys. Just remember this edition every Saturday, the Law and News, brought to you by my firm, Washington Law Firm. I encourage you to press the like button and share the live so that the people who need to get this information, the right people, will get in contact with the information. And if you're looking for legal consultation, if anything that we discussed today, you're looking for advice because you have assets and you want to make sure that those assets are protected for your generation behind you, guys, call the number there. You see it on the screen, 718-877-3100. And it's time for people in our community to recognize how to start back to build your generational wealth and ensure that the people behind you don't have to work as hard as you do. Guys, you heard the story about what Clairmont mentioned about the lady, regular working class woman, how she was smart enough to put her assets into a trust to ensure that her children would benefit from her estate when she's gone. So, guys, pay attention. This is educational. This is for educational purposes only. It's not intended to be legal advice or legal consultation. If you're looking for legal advice or legal consultation, you have to give the office a call and, book a free 50 minutes consultation where we can provide you with more information based on your particular situation. This is just general information and it's not specifically tailored to any specific person. And this is like I said earlier, this is a way for you to build generational wealth. Generational wealth is generally built through trust, not through individuals, because you give your property to an individual or you leave it in a will, is likely to be sold. And the person is going to take the one-time money and that money is going to be gone. But if it's a situation where you have a trust and somebody's managing income producing property, that is likely to bring wealth to your family and your generation following behind you. All right, Clairmont, we're getting ready to wrap up. Do you have any closing remarks you would like to give to the audience before we go?
Well, yeah, only that the disclaimer is that this is not legal advice and it should not be acted upon without consultation. And the second thing is that if you're in our jurisdiction, which is in the US and New York and Jersey specifically, and you have property abroad, which is in the Caribbean or Africa or even in Europe, it still falls within the jurisdiction of where you are. So you feel free to consult even on properties abroad.
Yes. Thank you, guys. Don't forget, I'm also licensed in Trinidad and Guyana. So if you're looking today, guys, and you need any legal advice, and you see Clairmont there, he's licensed in New York and New Jersey. So if you are interested in anything that we said today, don't forget, click the like button, like and share, guys. Thank you so much for all your support, guys. And I hope to see you again next Saturday at 4 p.m. sharp for the Law and You. Thank you so much for joining me today, Clairmont, and thank you for all the valuable information you shared with my audience today. Thank you, guys. See you again next week.
Thank you.
Bye.